Hi there, thanks for joining us. In this video, we're going to be talking about what you may be able to do if you've applied for a Canadian visa, a work visa or a study visa, or to visit Canada as a visitor, only to have that application refused. What are your options? What do you do in that situation? We'll have more on that after the break. As normal, please go ahead and hit the subscribe button, like this video, and check us out on our website at go.gooselaw.com. We'll be right back. Welcome back. My name is Donovan Francis, and I'm a Canadian immigration lawyer who helps skilled workers inside Canada and outside Canada to become Canadian permanent residents without having to deal with all of the complicated legal forms that are part of that process. Now, one of the most difficult things that persons wanting to visit Canada can sometimes encounter is having their work permit or study permit or visa application refused. This is not uncommon. Work permit or a visa may be refused for a variety of reasons. It's important to understand that the ultimate decision on whether or not any such application is going to be approved will rest with the Canadian immigration officer who is reviewing the file. So where your application has been refused, what are your options? What do you do? Well, first of all, when clients come to us with an application that has been refused, let's say you applied for a study permit and your study permit application was refused, the first thing we'll want to understand is the reason for the refusal. And if on our assessment we determine that there was a clear error on the part of the officer, that you had everything in order, all of your ducks were lined up in a row, then we might want to recommend that you request for what's called a reconsideration. So this is where we're asking the immigration authorities to reconsider their decision to refuse the application because the basis on which they arrived at that decision is unreasonable, unjustified, unwarranted. So that is one option, a reconsideration. And that's something that is not too demanding. We pretty much would put together a reconsideration request and send it to the authorities and wait for them to respond. So that's option number one. Alternatively, where we have determined that based on the reasons provided by the officer, that there was in fact some flaw or deficiency in the application, we might recommend that you file an entirely new application that addresses the concerns that the officer would have raised in the reasons. Now, it's important to understand that when an officer makes a decision to refuse an application, that officer is obligated by law to provide reasons for the refusal. Okay, and these reasons are going to be included in the officer's notes. However, when the immigration authorities send you notification of the refusal, they do not provide you with the officer's notes. They provide a very vague, generic refusal letter. And so it's going to be very difficult for you to understand the real reasons, the key reasons for the refusal. And so what we would do in that situation is to file what's called an ATIP report, which is an Access to Information and Privacy report. And in that request, we would ask that the officer's notes, the reasons for the refusal, be provided to us in that ATIP request. And then based on the reasons provided in that request, we would then be able to file a new application that would address whatever concerns, whatever deficiencies there might have been in the initial application. And this can be an effective way to address a refusal. I've seen situations in the past where persons have had their study permit application approved after having been refused 3 times previously. So that definitely is an option. The option of last resort is to file an appeal challenging the decision in the courts. Okay, this kind of appeal would have to be what's called a judicial review, and this is an appeal that's done in Canada's federal courts. And the reason why you do a judicial review is that, persons applying for visas outside of Canada do not have the right of appeal. You know, if you're applying for a regular study permit or a regular work permit or a regular visa, you do not have an immediate right of appeal. And so we have to do what's called a judicial review or seek leave to have a judicial review, which is a hearing in front of a judge at Canada's Court of Appeal. So that would be your option of last resort. But the important thing for you to understand is that if you have been refused, if your application has been refused, you have options. And so you always want to check with a lawyer to have that lawyer walk you through the options and to help you along the way to having your application eventually approved. So thanks so much for staying with us. And as always, remember to hit the subscribe button, hit the like button, and check us out on our website at go.gooselaw.com.